Dames en heren, aan deze bijzondere universiteit hebben wij de gewoonte om elke zitting te openen met gebed. Spiritus Sancti gratia illuminet sensus et corda nostra. Gaat u zitten. Dames en heren, welkom bij de Radboud Universiteit. Bij deze feestelijke gelegenheid waarbij wij een nieuwe hoogleraar in ons gezelschap verwelkomen. Een speciaal welkom ook aan de partner van de nieuwe professor en aan de ouders van de professor. Calorosa benvenuto. Professor Pietro Ortolani heeft een indrukwekkende lijst van aanstellingen gehad bij diverse instellingen. Ik noem Queen Mary, University of London. Ik noem het Europa Instituut in Saarbrücken. Hij is bij Max Planck Instituut in Luxemburg geweest. En een guest lecturer bij de Universiteit van Milaan. Ik heb een zoon die advocaat is. Ik zal hem dit straks sturen en zeggen dat ik graag zou zien dat hij dit ook allemaal doet. Voor nu wens ik u heel veel succes bij uw lezing.
Dank u wel. Meneer de rector magnificus, geachte decaan, ladies and gentlemen, in the lecture room and online. Let me start with a question. Are the lawyers in danger? Are the lawyers about to be substituted by machines? Are judges about to be replaced by algorithms? Is a robot about to enter the room and snatch this microphone away from me and claim that it can teach the law better than us, the humans? As lawyers in 2021, these are recurring nightmares. On the one hand, we have a system of justice that we have built over centuries with painstaking analog detail. On the other hand, a seemingly ungovernable wave. Digital technologies, Silicon Valley disruptors, irreverent innovators ready to make the law, and the lawyers obsolete, following one commandment: move fast and break things. Now, these concerns are not unique to the field of law. They also exist in the field of commerce. Electronic platforms taking over the market, destroying the economic fabric of small brick-and-mortar shops, substituting workers with robots. Let me read you a direct quote from a scared, exasperated shop owner. I quote, "Has anyone ever seen such things? A shop selling everything. And the employees, they work like porters at a railway station, treating both goods and customers as if they were so many parcels, taking themselves off or getting fired at a moment's notice. It's a world with no affection, no morals, no taste." End quote. Now, these are heavy words, and it's such a striking image. The brown package, the anonymous geometric shape of electronic commerce that has become inescapable for all of us, especially during the COVID-19 pandemic. The merchandise becomes a series of indistinguishable packages. The workers become packages. The consumers become packages, losing all resemblance of human uniqueness. The question is the justice system facing the same risk? Are courts about to be swallowed by an army of platforms, algorithms, robots? Are we about to witness the Amazonification or Googlization of justice? Well, maybe, just maybe, reality is a little more complicated than this. Maybe the time has come to move beyond the stereotype man versus machine. And in fact, I have a little surprise for you. The quote I just read to you does not come from 2021. It is a little older. It comes from 1883, from Émile Zola's novel, Lady's Paradise. In the novel, a small shop owner complains bitterly, as you have heard, against a new monster about to take over his business. In 1883, the new monster is not e-commerce, it is the department store. So what's the moral of this story? Why do I start from here? The moral is, these fears of disruption are not unfounded, but they are not unprecedented either. To a certain extent, the new has always been substituting the old. Disruption and tradition have always been dancing hand in hand. And that's a real message I want to start from. Our world is changing, but we do have the instruments to understand and to control that change. That is what the law is for. That is what the university is for. And that is my proposal for you today. That we move beyond the stereotype and we gain a deeper understanding of the topic of the chair that we inaugurate today. Digital conflict resolution. My lecture of today proceeds in 3 steps. The first step is descriptive. I will trace the emergence and the current state of what I call digital adjudication. Against this background, I will then sketch out a proposal for a new notion of due process, suitable for the digital age. The third step will be eminently practical. How to go about it, why now, and why here. Before I start with my descriptive overview, a disclaimer is in order. I observe this phenomenon from the point of view of my expertise, and that is civil and commercial dispute resolution. Therefore, my analysis will apply to court litigation in these matters, and also to private adjudication in these matters, namely arbitration. My analysis will also apply to online dispute resolution, ODR, aimed at resolving private disputes. However, other fields of justice, for example, criminal justice, call for a different analysis, and they fall outside of the scope of my lecture. A fortiori, my analysis is not also applicable to administrative decision-making. Technology is making its way into civil and commercial dispute resolution. And if we take a quick comparative look around the world, we often come across reports, sometimes enthusiastic, sometimes alarmed, about fully digitalized courts, where the parties and their lawyers interact with the judges through digital means. The case file is entirely digital. Witnesses are heard via video conference. The case law is analyzed through quantitative means, and the judgment is delivered electronically, maybe even recorded on a blockchain. This trend towards digitalization of civil justice has several drivers. I will briefly outline 4 factors that act as catalysts in this sense: the quest for efficiency and cost minimization, international regulatory competition, the COVID-19 pandemic, and the impulse of the disputing parties themselves. Starting with the first one, the digitalization of courts is increasingly adopted as a metric, as an indicator for the evaluation of the quality of a justice system. The assumption is more digitalization, better quality. A good example in this respect is the EU Justice Scoreboard, a yearly exercise that aims at empirically measuring the quality of justice in the EU member states. And among the very variables that we find in the scoreboard, we find, and I quote, the availability of digital solutions to initiate and follow proceedings in civil or commercial cases. Now, the idea that more digitalization automatically leads to better quality is far from uncontroversial. In fact, I find it to be a very delicate assumption, which has sparked criticism in the literature. The idea that full digitalization is the only conceivable future for all facets of dispute resolution could in fact be seen as yet another expression of what theorist Mark Fisher defines as capitalist realism. The use of econometric methods to measure justice may trigger a race to box ticking and not to actual justice. Yet, whether we like it or not, these incentives are here to stay, and they are progressively being embedded into positive law. An example in this respect is the still little known e-codex regulation, a new EU package of software products allowing digital communications among member state courts. The member states of the EU are not forced to join yet, but they're clearly nudged by the EU to do so. The second factor triggering the digitalization of civil justice is regulatory competition. Especially for commercial cases, justice is increasingly seen as a free market where courts and arbitration compete with each other to attract high-value cases. And the experience of the London Commercial Court, for example, demonstrates already for decades that justice can be a big business. And now, especially in the wake of Brexit, this competition happens at a worldwide scale. The Netherlands is no exception with the Netherlands Commercial Court. And international commercial courts proliferate all over Europe and the world. In this context, remote hearings, electronic taking of evidence, blockchain verification of judgments, they all become interesting, attractive items on the menu for the clients to choose from. Once again, we might be very skeptical about this commodification of courts, but yet the phenomenon is undeniable. And depending on the future success of instruments facilitating the international circulation of judgments, such as the Hague Convention on Choice of Court agreements, such competition will become even more intense. And with it, the push towards digitalization will also grow. The third factor is, unsurprisingly, COVID-19. The pandemic has acted as a fundamental catalyst for digitalization of courts all over the world. Even in legal systems traditionally reluctant to embrace digitalization, the pandemic has triggered a shift. It has cast an unprecedented spotlight on calls for fully digital justice. Among the many voices in the debate, suffice it to mention Richard Susskind and his online course and the future of justice. Now, to translate this into reality is not easy, as the Dutch K experience clearly demonstrates. Yet, the push towards digitalization is here to stay. So far, we have seen how the digitalization of civil justice is being pushed and incentivized all over the world. And yet, there is also another fundamental and often disregarded driver: us. Us as in the lawyers operating in procedures, but first and foremost, us as in people. People who may have a dispute. What do they want? They want many things, but typically, they want to win. That's what you want when you have a case. And in an attempt to win the case, often they are the ones who inject technology into civil justice. For instance, using data mining to analyze voluminous case files, or to algorithmically analyze case law in order to convince the judge through quantitative methods rather than simply through rhetorics, or to determine whether third-party funding of litigation or arbitration is a viable option. Let me give you a practical example that might be interesting for the dispute resolution specialists. In the famous UCOS case, the Dutch courts were asked to determine whether significant portions of the arbitral awards signed by a three-member PCA tribunal constituted under the Energy Charter Treaty had in fact been written by somebody other than the arbitrators. Now, this is a widely known ground for annulment of an arbitral award, the improper constitution of the tribunal, which Dutch law largely borrows from the 1958 New York Convention. And if we read the law there's nothing digital about this. This is an assessment that the court needs to make in order to decide whether to annul the award. And yet, in that case, both parties, in an attempt to convince the court, have presented the court with a computer-generated statistical stylometric technique. And all of a sudden, the court is presented with an algorithm. In this case, the law hasn't changed at all. But there's already an algorithm in front of the judge. There's already, if you will, an invisible robot in the courtroom, because the parties have an incentive to bring it in. The parties have an incentive to accelerate this transition. The parties want to win. So far, I have charted the emergence of digital adjudication in state courts, as well as in arbitration. But what if I told you that while we were here calmly discussing the pros and cons of digitalization and worrying about the specter of a robot judge, in the meantime, a robot judge already exists? What if I told you that in the time it takes me to pronounce this sentence, the robot judge has adjudicated 7,000 cases? It's that fast. And it's not science fiction, it really exists. Yet, if you would go to the local court in Arnhem, you would not find such a powerful digital adjudicator. Instead, you would find it in two other places. One of them is a little far away, but the other one is closer. The first place is Menlo Park, California. The second place is closer. It is your pocket, your telephone. The digital adjudicator is called Facebook, or maybe now I should call it Meta. Maybe it's too meta if I call it Meta. But similarly to Facebook, Amazon, eBay, and every other very large platform, both e-commerce and social media platforms, and the lines are increasingly blurred, adjudicate an ever-growing volume of private disputes every moment of every day. Only an extreme minority of them will ever go to a judge or to an arbitrator. And so, the world we live in is already today a world of online dispute resolution, ODR, where platforms resolve cases at an impressive speed, combining automatic decision-making with fast-paced human intervention, and increasingly, as we will see later on, quasi-judicial bodies, setting a rule of precedent in these transnational digital spaces. Once again, this is a development we may be very critical about, very skeptical about. But for now, I'm just making a descriptive diagnosis. And remember, my message to you was, we have the instruments to understand and to control this change. To summarize the descriptive overview I have offered so far, the world of civil and commercial dispute resolution that we face is increasingly digital. It is also increasingly hybrid. We do not face a binary choice between robot adjudication and good old traditional human judge. Instead, technology is already seeping through the system today in often invisible ways. What we are facing is what anthropologist Nick Seaver calls an algorithmic system, a heterogeneous and diffused system where human and machine coexist. It is increasingly a transnational network of interrelated systems of justice. And it is also a world where the boundaries between private and public are increasingly blurred, with state courts using private technology or being presented with it, whether they like it or not, and private actors, platforms, for example, discharging public, quasi-sovereign dispute resolution functions. Generic as they may be, let us keep these broad conceptual labels in mind: digitalization, hybridization, transnationalization, and privatization. They will be useful for the remainder of our analysis. I will now progressively switch gears from descriptive to prescriptive. So this is the world we live in, and you might ask me, what's the problem with it? Is there a problem with it? I think there is a problem with it. The problem is that our current notion of due process the notion that we have so carefully been cultivating through centuries and teaching at law school is no longer sufficient. It is no longer adequate. We have a set of guarantees. Among the most important ones, the right to an independent and impartial adjudicator, the principle of equality of arms, the fundamental right of access to justice in the first place. These guarantees are embraced by most modern systems of law, and they are also enshrined by international human rights law, first and foremost by Article 6 of the European Convention on Human Rights. They are a key element of the rule of law. They ensure that dispute resolution results in justice. The argument I will make now is that this fundamental cornerstone of dispute resolution, due process, is in need of an update. In this respect, I have three main proposals for you. The first proposal concerns the scope of application. Traditionally, due process has been developed having in mind courts and court litigation. Why? Well, because litigation leads to a final resolution of disputes with res judicata effects. This ensures finality and precludes the relitigation of the case. But also, it leads to the issuance of a title, the judgment, which is enforceable in the jurisdiction where it's issued, and increasingly throughout the entire area of freedom, security, and justice. And for these reasons, given the key functions of civil litigation and the crucial effects that it produces, sufficient guarantees must also be in place. Now, these guarantees do not apply at all to the brave new world, so to speak, of online dispute resolution. Take my previous example of very large platforms, adjudicating an ever-growing number of cases, ruling on the parties' rights and obligations. That form of private adjudication falls, for now, entirely outside of the cone of light projected by due process. ODR remains, for now, in the shadow. And you might object, it does, but it does for very good reasons, because it's a completely different animal. It does not lead to res judicata effects. It does not lead to the issuance of an enforceable title. It's just completely different. You would be right. Eppur si muove, somebody would have said, yet it moves. Yet, in practice, these legal distinctions are losing their grasp on the reality of digital conflict resolution. In practice, platforms have very powerful means of enforcement. Actually, they exert quasi-sovereign powers on that transnational digital space that they have created. As a consequence, they can ensure the enforcement of dispute resolution outcomes. In theory, the parties remain free to go to court, but in practice, they will almost never do so. For these reasons, if we want to make sure that digital conflict resolution leads to digital justice, we must enlarge the scope of due process. Let me put it like that. The city where we are in right now, Nijmegen, Nimega in Italian, and the city I lived in before leaving Italy, Lucca, no Dutch translation as far as I know, they have one historical problem in common: walls. They were both fortified cities, and they were merchant cities. They traded with the outside world, probably even with each other. And because of this, the city grew. And at some point, it could no longer be constrained within the old walls. Now, it would be a fool's errand to try and stop a city from growing and evolving. Max Weber, I suspect, would agree with me at least on this. What we can do instead is find new ways to protect our cities. In this case, of course, the walls are due process. And we have the task to protect those who live in the ever-growing, diverse, exciting, evolving, problematic citadel that is civil justice. The second proposal concerns the approach to due process. Due process, I contend, must become digital in two complementary senses. On the one hand, in the first part of the lecture, I have described the different ways in which digital technologies are permeating dispute resolution. Therefore, whenever we design dispute resolution procedures, whenever we make procedural law, but also whenever we are active within those proceedings, as judge, as arbitrator, as counsel, we must pay close attention to the effects of digitalization on due process. Digitalization of procedures will likely change the way in which people access justice. That can be very good. But it will also create new forms of digital exclusion. It might lead to algorithmic discrimination. It will certainly lead to obstacles for many sectors of our society. These cannot possibly be ignored. Embracing digital due process means considering these effects systematically and critically, rather than embracing the assumption that more digitalization always leads to better quality. Digital due process allows us to overcome the illusion, because it's just an illusion, that the quest for procedural efficiency takes place in an ethical, political, and legal vacuum. Digital due process is a North Star in our pursuit of fairness in digital adjudication. This is an urgent challenge lying ahead of us. To not build a new digital notion of due process is to destroy due process as we have it today. But there is also another meaning of digital, a flip of the coin, if you will, that I would like to briefly discuss with you. As I mentioned in my descriptive analysis, people increasingly seek conflict resolution outside of the traditional channels of courts, arbitration, binding advice, etc. Instead, they resort to online platforms. Think of e-commerce, but think also of content moderation on social media platforms. Whenever these platforms create the interfaces, the systems through which people can seek redress, through which people can seek justice, they write code, as in they write software. But they also write code, as in they write a code of civil procedure. And that is why we need a new, more encompassing and digital approach to due process. Procedural law determines the allocation of powers and responsibilities in an orderly adjudicative dispute resolution procedure. That is what we have built an entire tradition of procedural law on. That is what Miriam Damaska describes as the basis upon which a legal system builds not only its system of justice, but its very idea of officialdom. And now, in 2021, this allocation of power is largely carried out through technology, through code. And we, as procedural lawyers, as positive lawyers, as people who care about Dutch legal practice, as people who care about the effects of law on Dutch society, we need to get our hands dirty. We need to get in there. We need to make sure that due process is already embedded within that technology. We need due process by design. We need, I repeat, digital due process. To not build a new digital version of due process is to destroy due process as we have it today. Third, this new notion of due process must be transnational. When I use the word transnational, of course, I am standing on Philip Jessup's shoulder. I am thinking of a notion of due process that binds not only states and their justice system, but also global private actors and their normative orderings. This, in turn, requires a flexible approach to due process, a certain modularity, if you will. What I mean is, the old due process created with respect to courts cannot be simply copy-pasted into the new reality of ODR. If we did that, we would lose flexibility, we would lose speed, we would lose those things that make ODR actually work. And yet, inasmuch as submission to ODR is no longer entirely voluntary, these guarantees cannot be disregarded altogether either. You may object that if we adopt such a flexible, modular approach to due process, we end up diluting the guarantees that we wanted to reinforce in the first place. To this, I would answer that, unlike for other fundamental rights, such a modularity, such a flexibility, is already a structural feature of due process. We see it, for example, in the application of Article 6 of the European Convention on Human Rights to arbitration. With respect to arbitration, the provision applies, but only inasmuch as the parties have not freely and willingly waived its application. And therefore, the voluntary versus compulsory nature of a party's engagement with dispute resolution is crucial. And the flexibility we need is already there. We just need to use it wisely in this new digital reality. So far, my argument goes, the rise of digital adjudication calls for a new notion of digital due process. You may be thinking, well, this is very fascinating, but it's terribly abstract, it's theoretical, it's removed from legal practice. I want to reassure you, the third step of my lecture will be eminently practical. How can we build this new notion of due process in practice? And why should we do it here, in the Netherlands, and in particular, in Nijmegen? My story so far can be seen as a chess game. Digitalization has made its move. And now we, the lawyers, must make our move. I suggest that we make two moves which complement each other. And importantly, they operate at different levels. First, the level of legal practice. These are practical proposals for the interpretation of the law as we have it today, de jure condito, and for the reform of the law, de jure condendo. Second, the level of academic pursuit. These are lines of a research agenda. But third, these are also guidelines of legal education. In this vision, students are crucial. They are not at the receiving end of an intellectual supply chain. They are the lawyers of tomorrow. And we, today, have a responsibility of equipping them with the tools they will need in their future. Students, the lawyer of tomorrow, in this vision, are front and center. The first chess move I would like to discuss with you is what I would call the Accelerationist Gambit. We have seen how technology developers increasingly make procedural law through code. We have also seen how some of them have such extensive powers at the global level that they discharge quasi-sovereign dispute resolution functions. And then the question arises whether at some point they may end up judicializing themselves, embracing their role as global courts of the internet, and with that, giving effect to digital due process. Just like in 1667, Louis XIV felt the need to issue the Ordonnance Civile, anchoring justice to state authority and subjecting all judicial authorities to the same law, the postmodern digital sovereigns of Menlo Park, of the internet, might feel the need to embrace digital due process because it is an unavoidable step in what Teubner would call their constitutionalization. You might object, this is fascinating, but it's unrealistic, this will never happen. You would be wrong. Not only it could happen, it has, in fact, already happened. In 2019, Facebook came to the point where it had no choice but to acknowledge that its constant stream of decisions on content moderation amounted, in fact, to a form of adjudication. In fact, adjudication on fundamental rights. In fact, balancing of fundamental rights. And isn't there anything more intimately judicial than a balancing test? Well, when Facebook acknowledged that, they did not try to fix the problem by creating a new algorithm. They did not try to build the perfect robot judge. And mind you, Facebook has the best artificial intelligence expertise on planet Earth. What they did instead is very traditional. I would say what they did is ancient. They created what is, in practice, a Supreme Court. It is called the Oversight Board. It's a court-like structure with a budget comparable to the one of the ICJ and a growing, fascinating case law on content moderation. To be sure, I am not arguing that we embrace these developments enthusiastically. We can and we should remain critical, even skeptical. But we cannot ignore it. We can choose to look at the phenomenon, at these quasi-judicial authorities, and recognize what Neil Walker would call intimations of global law. More practically, if these platforms are the forum where an ever-growing number of people seek justice, where disputes are being adjudicated, we need to teach our law students about this growing system of law, because they won't be able to ignore it 10 years from now. And I suggest we should not ignore it already today. So far, an accelerationist move. But that is not the only chess move we could do. Next to it, there is a complementary defensive move. It is what I call the Brussels defense. We could inject digital due process by way of lawmaking. We can, and I argue we should, make sure that the new generation of EU instruments embodies the guarantees of digital due process. To date, this commitment to due process is visible, but it's not sufficient. It is not consistent. It has remained in the background, and it's time we take it to the front. I will give you two practical examples, and I will be very positivistic. Let's talk about articles. The European Commission has proposed a new ambitious regulation, the Digital Services Act, DSA, with the purpose of creating a new accountability framework for platforms. And yet, Article 34 of the DSA fails to provide for any standardization of the so-called internal complaint handling procedures of platforms. This is because the DSA fails to see that these procedures are, in fact, the avenue through which an ever-growing volume of individuals seek redress. That's where they seek justice in 2021. Let me put it like that. Imagine what would happen if I would enter a lecture room and I would tell the students, look, don't worry, there is a code of civil procedure. It's just that I cannot really teach it to you because every court has its own and they change it all the time and they don't even bother telling us that they have changed it. Now the students would boo me out of the lecture room and they would be right. We would never accept something of this like this from a state. And why would we accept it from a private entity? I think we shouldn't. But if we do not recognize in these interfaces and in these procedures a new system of digital adjudication, we also cannot regulate them as such. A serious and consistent commitment to digital due process achieves exactly this. And let me give you another example. Another proposal currently being discussed in Brussels is a new regulation on artificial intelligence, the so-called AI Act. The regulation tries to distinguish among different uses of AI depending on the risks that they pose. So there are high-risk systems and low-risk systems. In the list of high-risk systems, we find, and I quote, AI systems intended to assist a judicial authority in researching and interpreting facts and law, and in applying the law to a concrete set of facts, end quote. This is a robot judge. It's high risk. I agree. Now, for high-risk systems, the regulation sets forth a number of important guarantees and protections. However, in the case of civil justice, these guarantees and protections only apply if the system is used by a judicial authority. So if this regulation were a piece of technology, it would actually be a very traditional piece of technology. It would be an electricity switch. It follows a binary approach. It goes on, it goes off, there's nothing in between. But the reality of dispute resolution, as my analysis has shown, is much more nuanced than that. In dispute resolution, technology is constantly repurposed and reimagined by different stakeholders with different agendas, with different incentives. And so, What if the same system is used not by a judge, but by a third-party funder to decide whether to fund a claim or not? Isn't there a risk for due process there? Isn't there a risk for access to justice there in a system that increasingly relies on private capital for litigation and arbitration? I think there's a huge risk there. And what if the system is introduced in the proceedings by one of the parties in an attempt to convince the court? And what if the other party has no means to produce a similar system and even to understand that system and to understand why that system produces certain results? Isn't there a risk there for the principle of equality of arms? Once again, isn't there a risk for due process there? I argue there's a huge risk there. And how do we counter these risks? As I mentioned in the beginning, we should go beyond the stereotype human versus machine. We should go beyond the binary approach. We must become more adaptive. The same technology can entail different types of risks depending on how, by whom, and for what purposes it is used. And in dispute resolution, technology is constantly reimagined, repurposed, reinvented. Therefore, we need an adaptive response. And hopefully, I have convinced you that this solution is digital due process, a serious and consistent commitment to the implementation of digital due process in the future of Dutch and European law. We need to build a new notion of due process, and the last word of my lecture is the most important one. We must do it together. Together means, first of all, private and public lawyers together. The examples I just mentioned have great practical relevance for private lawyers operating within these proceedings. But they also have a lot to do with public values, with fundamental rights. And these cannot be ignored. Only if we work together can we build digital due process. Together also means jurists must embrace interdisciplinary work and cooperate with colleagues from other disciplines. Computer scientists, cognition scientists, political scientists, economists, philosophers. These perspectives must enter into active dialogue with the law. And today, we have an unprecedented opportunity to make this happen. I repeat, together. The law faculty of Radboud University is involved with the other Dutch law faculties in the sector plan, a nationwide research plan offering unprecedented momentum for this type of innovative work. This is our chance. Let's take it, and I repeat, let's take it together. This last word brings me to the moment of thanks. I want to thank the university's executive board for the trust they have put in me with this appointment. I want to thank the faculty board, the dean, both of the vice deans, and the managing director for their trust and for their support. I want to thank the Radboud Business Law Institute for being an invaluable point of access into the reality of business law in the Netherlands, and the STER Research Center for bringing a crucial insight on public values and on the practical effects of law on society. I want to thank everyone who is involved in the sector plan and all of the trekkers for your enthusiasm, your expertise, and your constant work. My deepest appreciation goes to all of you. I want to thank all of my department, Burgerlijk Recht, for having welcomed me to Radboud and for always making me feel like a valuable member of your team. All of you, and you are too many to be named individually, have made this experience truly unforgettable. A special word of thanks goes to Steven Bartels and André Jansen for their constant encouragement and guidance. I want to thank the students. I am happy to see some of you in the room, and I hope to be able to discuss these topics with you and to learn with you and from you for many years to come. I want to thank my friends for their constant presence and my entire family. In particular, I want to thank my parents, il mio babbo e la mia mamma. Grazie di tutto. I want to thank Marloes for always being my shelter from the storm, and her family for making me feel truly at home. I have started my lecture with a quote from a novel. Let me end on a quote. Don't worry, this one is not a trick quote. In her 1969 masterpiece, The Left Hand of Darkness, Ursula K. Le Guin makes stunning predictions about the future. This is what she writes. Legends of prediction are common throughout the whole household of man. God speaks. Spirits speak. Computers speak. Oracular ambiguity or statistical probability provides loopholes, and discrepancies are expunged by faith. So according to Le Guin, even the most advanced technology leaves some gaps open, and these gaps must be filled with faith. But faith in what? I hope that my lecture of today has convinced you that we should all, together, keep alive our faith in the enduring power of the law. Ik heb gezegd.
Professor Ortolani, heel veel dank voor een inspirerende, overtuigende lezing die zelfs voor niet-juristen heel goed te begrijpen is en over een heel belangrijk onderwerp ging. Naar aanleiding daarvan kan ik u zeggen dat ik volledig gerechtigd ben om de rechtenfaculteit te feliciteren met uw aanwinst, de studenten te feliciteren met een zo overtuigend docent en u allen voor uw aanwezigheid bij deze gelegenheid. Ook de mensen die ergens in cyberspace ons gevolgd hebben, dank voor uw aanwezigheid. We zijn nog steeds een bijzondere universiteit en ook bij het slot willen wij dat met een gebed herdenken. Wilt u daarvoor gaan staan? Gratias tibi agimus omnipotens Deus pro omnibus beneficiis tuis, qui viviset regnas per omnia saecula saeculorum.